Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within for the Commonwealth. Draw near, give attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Blake. To my right is Justice Desmond. To my left is Justice Singh. We are the panel for today's cases. The late start today is due to the fact that today is Justice Englander's last sitting. He is retiring this year, and we had a little celebration for him in Courtroom 4. I hope some of you were able to join in that celebration. He is going to be missed sorely. But with that, we will get to today's list. I know most of you have been here before, but just a few brief reminders. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials, so my suggestion is that you get right to your arguments. With that, I will call the first case, Commonwealth versus Christopher P. Hamilton, docket number 24P763. Good morning, Mr. Corman.
Morning, Your Honors. William Corman on behalf of the defendant. It's a pleasure to see you all again. I recognize that I am swimming upstream here, where I'm bringing up an unpreserved argument regarding a closing, one sentence or two in a closing statement. I do want to just reiterate on behalf of Mr. Hamilton the allegations of impropriety in the actual closing argument itself, wherein we have a Commonwealth making what I would consider respectfully an inflammatory remark right out of the gate during the closing argument by suggesting that Mr. Hamilton could not help himself or could not control himself when it came to the allegations in question. Respectfully, and just so the court's aware, the timer is not on. Not that I'm concerned that I'm going to run over 15 minutes, but just so the clerk's aware. I would, again...
I'll make sure Ms. Lazar gets her time.
There you go. Again, what we have here is we have what I was saying respectfully to the Commonwealth is just an inappropriate statement made that does not need to be made. And I am again imploring the court to consider snatching victory out of the jaws of defeat here, where the government has once again made what I would consider an inappropriate closing argument. The court has... What
you've done, and you always do this, which is why you're so good at your job, is you've isolated one sentence.
Your Honor.
But don't we have to look at it in the context of the entire closing and of the evidence? And if the only sentence was Christopher Hamilton simply could not get enough, I don't know that we'd be here, but there's more than that. So help me with our standard of review and what we're supposed to look at.
Absolutely, and obviously the fact that this was an unobjected to statement, it's an unpreserved argument, which certainly puts us at a significant disadvantage. Nevertheless, the suggestion is that although the court does need to take a look at the closing argument in its entirety, and that's well-settled case law, the fact of the matter is that just because this court is required to look at the argument in its entirety does not give the government a free pass. In other words, they shouldn't be able to make some inflammatory statements in the midst of a lengthy closing argument and then be able to rest on their laurels and say, well, we know the appeals court is going to look at the entirety of the argument, and therefore we should be able to get away with a few things here or there. That's not right. It's not fair. It's not fair to Mr. Hamilton nor the many other individuals whom I've represented and my brothers and sisters have represented where there are improper statements made in closing argument. At some point, the dam has to break. They can't just keep getting up there and making improper statements.
If we're looking at reasonable inferences from the evidence, right, we have the testimony that when each of the victims visited the house on the days of the crimes, at least the evidence that the jury seemed to credit, because he was convicted of everything, was that your client was focused on getting each of these young girls alone in his bedroom for the purpose of what became a sexual assault. If you marshal that evidence with the reasonable inferences therefrom, trial counsel is in context listening to it, experienced counsel, no objection. I hear what you're saying. There are times that the prosecutor pushes that limit. I hear you loud and clear. I don't know that this is it.
Again, I'm suggesting that while they certainly are allowed to draw fair inferences from the state of the evidence, nevertheless, I would suggest the Commonwealth has to balance that against what what an inflammatory remark could be. Saying Christopher Hamilton simply could not get enough, I think, is an inappropriate statement, regardless of the state of the evidence, especially because that's what they're saying from the rip. And again, I'm suggesting that the government knows the standard, and the government should follow the standard and not sort of wink and nod at the fact that they are then going to give an entire closing argument that may be proper. At some point, they need to be held accountable for these statements, and I'm suggesting that this is that case. Thank you very much for your time.
Thank you. Attorney Lazar? Let's just make sure we get the clock reset.
Okay.
Thank you.
Thank you. Good morning. Ellen Lazar for the Commonwealth. This court should affirm the defendant's convictions because the prosecutor's closing argument was proper. The evidence in this case showed that on 3 occasions, the defendant sexually assaulted the child we call EJ while the child was in the defendant's house to play with the defendant's nephews. On one of these occasions, the defendant picked EJ up, threw her over his shoulder, carried her to his bedroom, and threw her on the bed where she hit her head, and then sexually assaulted her. On another occasion, he sexually assaulted her while she called for help in his bedroom, and his nephew, who was outside the door, was trying unsuccessfully to get into the room. A few months later, he sexually assaulted another child, S.A., while she was at the house to play with the defendant's nephews. He began this assault in the living room, despite that his nephews were upstairs. One of the nephews had literally just gone upstairs to get a toy when the defendant began this sexual assault. He then, in the victim's words, rushed them to his bedroom so he could continue the assault. That assault was reported on the next day, and so after that point, the defendant lost access to these children. In light of this evidence, the prosecutor properly argued that the defendant could not get enough of these children because he clearly was not satisfied after 1 sexual assault, or 2, or 3, and was only stopped after the 4th sexual assault. And there certainly was a suggestion in the evidence that he was acting under some level of compulsion where he was committing sexual assaults on these children while his nephews were nearby. In one case, picked up a child and carried her to the bedroom. In another case, rushed her into the bedroom.
Well, let me ask you this. I know your argument is there's no substantial risk of a miscarriage of justice, but would you say that perhaps that sentence was better left unsaid?
I really wouldn't. I think this was literally, it was the first sentence of a closing argument that spanned 10 or 11 pages. He then backed it up with evidence supporting the statement that he was making, the evidence that I've just gone over, and there was more. So to say that I really think it was a proper argument, it was a proper sort of summing up of what was in front of the jury about 1 assault happened, and then the child came back, and then another one, and then the child came back, and then another one, and then when a different child was visiting, he sexually assaulted that child. But if the court disagrees and believes that the argument was improper, then it is the Commonwealth's position there was no substantial risk of a miscarriage of justice, given that it was a brief statement in an argument that covered 10 or 11 pages. Of course, the judge instructed repeatedly that closing arguments were not evidence, and as the court is aware, this court and the SJC have said multiple times that the jury is able to sort out hyperbole in an argument. If the court has no further questions, I would rest on my brief.
I see none. Thank you both.
Thank
The
you.
matter is under advisement. Our next case is Commonwealth versus Daniel Robert Malcarn, docket number 24P1263. Attorney Daniels, good morning.
Good morning, and may it please the court. Attorney Joshua M. Daniels for defendant appellant Daniel Mulkern. I think this case belongs to a sort of peculiar subset of ineffective assistance cases that are governed by Commonwealth versus Mahar, I think I'm saying that right, and Lafleur versus Cooper. In the typical or modal ineffectiveness case, the argument is basically that the defendant had a good defense, which counsel's deficient performance prevented the adequate presentation of. Here, the argument proceeds from the premise that Mr. Mulkern had no credible defense. He only had what the Commonwealth called during the motion to suppress phase, I think, a conspiracy idea. But his trial counsel failed to recognize that and failed to give him a realistic assessment of his prospects at trial.
Wasn't the defense's theory that the officer was rogue?
I'm sorry, Justice Desmond, I can't hear you.
The defense's theory that the officer, Robert England, was a rogue officer and had planted and rigged this case. Wasn't that the theory? Essentially,
yes, that he made it all up, and the other officers in his department also were in on a scheme to plant 1,200 oxycodone pills in the backpack that was found next to Mr. Mulkern when he was sitting alone in his mother's car in West Roxbury. The backpack, by the way, also contained his ID and his prescription medications, as well as various other drugs and drug paraphernalia. I think there was a drug ledger in there, packing materials, and $7,200 in cash, if I recall. And the theory was essentially that the police had lied about everything. They had planted the evidence, apparently for the purpose of framing him for no real discernible reason, as Judge Raschuti noted during the motion to suppress ruling, because, I mean, not all of the officers were even familiar with him. Detective Samaras had never encountered him before, so it's not clear why all of these people would risk their long careers with the Boston Police Department just to catch one, I'm not sure, one drug trafficker. And that theory had already been aired and explored fully at the motion to suppress and had failed spectacularly. I think Judge Raschuti's decision is rather scathing when you read it. And so, the trial judge, trial counsel gave a detailed preview of this theory to the trial judge the week before trial, and basically said, this is what the defense is going to be. And what the trial judge's reaction was, can't we do a plea bargain? And oh, by the way, you're not bargaining from any position of strength here, which if your strategy hinges on you going jury waived, that's a really sort of troubling data point. And given all that, I don't think any reasonably competent attorney would have called this a jump ball. I think, in all fairness, it's sort of weird for someone in my position to say this, but that is sort of the nature of this unusual claim. My client was dead to rights on drug trafficking with the count one of the case that was tried, and that was the count that carried far and away the greatest sentencing exposure. I think that was...
Do we know if counsel advised him to go jury waived?
He did advise him to go jury waived. He thought, given the assumption of a jury waived trial, that was his best chance. And if he went jury waived, it was a jump ball, which they both understood.
Yeah, I understand. And so, notwithstanding the strength of the government's case, as you've outlined, he was found not guilty of some of the lesser included offenses. Is that correct?
That's correct, but those dispositions were not a function of the strategy at all. They depended on an argument the trial counsel didn't actually make.
Were they a function of the strategy of going jury waived in front of Judge Locke?
I'm not sure if they were, but even granting that, I don't think any reasonable, competent attorney would have decided to go jury waived just in the hope of securing those dispositions when you have literally no defense on the lead indictment, which carries the greatest sentencing exposure, more than twice on the bottom and the top end of any of the other charges.
And of course, the lawyer didn't decide to go jury waived, right? He didn't decide that.
I didn't.
I said, of course, the lawyer did not decide to go jury waived.
When you say the lawyer, I think right. He advised Mr. Mulkern to go jury waived, and Mr. Mulkern ultimately made that decision following his advice. I think that when you have your lawyer saying effectively there is a chance it could go either way, that to me signals is essentially tantamount to advice to there is a possibility that I can win this. And particularly when your lawyer has, I think we can all sort of recognize a very strong reputation as a criminal defense attorney that carries some weight with the client. And the client, I think, as the Napper and the Alvarez cases lay out, the client is really looking to and deferring to the professional judgment of the attorney to advise them as to what to do. So I think—
Doesn't trial counsel do that? At record 69 in his affidavit, he explains exactly why he advised Mr. Malcarn to go jury waived and what he thought the trial judge would do relative to the defense about the officer and the failure to account for some of the notes and reports and discrepancies. I mean, he lays it all out in his affidavit.
Right. I just don't see any credible hope of that defense succeeding, and I think that was a manifestly—
Judges don't believe police officers all the time, and that's exactly what he's saying here, that his contemporaneous notes and reports, discrepancies between his testimony at the suppression hearing versus the police report versus the crime lab. Knowing that Judge Locke was a fair-minded jurist, he thought he could convince Judge Locke, quote, not to believe any of the Commonwealth's evidence because the police witnesses' accounts were inherently unbelievable. That's an argument made every day in every court in the Commonwealth, and judges and juries believe that. People are acquitted.
As an empirical matter, I don't know that— I'm not a trial attorney, so I don't know how often that argument is successful at trial, but and this court doesn't see the acquittals. So you might have, with respect, there might be a visibility problem there, but
You have 3 former trial judges sitting on this panel.
Fair enough. I don't think, given the evidence that was coming in, given the nature of the discrepancies that trial counsel was talking about, I mean, basically we're talking about sort of relatively minor inconsistencies in terms of like where did they begin the inventory search versus they have an alibi in the girlfriend's testimony that doesn't actually conflict with the Commonwealth's timeline. They have discrepancies about sort of misstating where the inventory search began. There are labs. There's the failure to keep track of the open bag of powder that Officer Englund saw. Says that he saw in my client's hand. I don't think any of these discrepancies really,
What sentence did he get?
He got 8 to 10 years on the drug trafficking, the count 1, and he got
Concurrent, right?
concurrent on and lesser sentences on the others.
And trial counsel was looking for a 4 to 6?
That was the counteroffer that was made during plea discussions, and the best offer on the table at that time was 5.5 to 7, a soft 5.5 to 7. So it's not a very large delta between them. I think it shows, segueing a little bit to prejudice, but I do think I need to fully address deficient performance, but segueing a little bit to prejudice, I do think the record here, and Judge Hogan didn't really dispute this in her decision, I don't think she got this far, that my client was in a dealing mood. And I think I think the Turner case from the Sixth Circuit.
When you say he was in a dealing mood, is that what you said?
Yes.
What do you mean by that?
He made a counteroffer, and everyone accepts that he made a counteroffer, which means.
No, I understand. The government offered him, I think, three potential pleas, right?
Yes.
And then he countered with 1.
Yep.
Right? And the defendant elected not to choose any of those.
Right, because he had been advised that.
All of those had less than the 8-year mandatory, right?
I think one of them was the 8-year mandatory. Like the offer going into the pretrial hearing was 8 to 8 in a day, and then 2 more offers emerged after the pretrial hearing that were less.
And the lawyer that we're talking about a very experienced lawyer, right?
Yep.
Who had very familiar with this particular judge. Would you agree with that?
Yep.
Okay, go ahead.
I still think it was manifestly unreasonable, and I don't think Judge Hogan, the biggest criticism I have of her decision is the way it reads is he made a judgment call, it was wrong, that's not enough. I think you need to at least say something about why there is any room for reasonable disagreement about the reasonableness of that judgment call. And without that, I'm not really sure how to understand how she understands Mahar. I think reading between the lines, it seems to me that she may be reading it as, well, it's a likelihood of success assessment and those just don't work as a categorical matter. I don't think that's right. If that was her reasoning, it's wrong. I think if you look at this record independently, this case was, as the Napper case seemed to the Pennsylvania court that I cited, a stone cold loser.
And yet this judge, sua sponte, found him guilty of the lesser included offenses.
Based on an argument about how you count the mixture, the mixed bag of three different drugs.
This judge, sua sponte, found him guilty of the lesser included offenses. Is that correct?
Found him guilty of the lesser included offenses? Yes. And he sua sponte came up with an argument about the mixture of three different drugs that no one talked about. It was not part of.
Judge did that on his own.
Yes, and I don't think, but there was no answer to the pills. That was essentially the Commonwealth's closing argument, was they have said literally nothing about the pills in the backpack. They have nothing to say about the pills in the backpack. And unless you have a good thing to say about the pills in the backpack, I don't think it's reasonable to go to trial when the lead charge that you're facing, which carries 8 to 30 as potential exposure, you have no credible defense to. And you have really, and all you can do is point to minor inconsistencies in the paperwork. I don't think that's, I don't think that's even arguably a reasonable strategic assessment of the case that he had before him. And I mean, I think, imagine it this way, and this is sort of relevant to prejudice too. I've been thinking of this as sort of the mirror image of the cases that you see very often, which is in the immigration context, you have there's a defendant who takes a deal, and then because who takes a deal gets a guilty verdict, and then they're trying to undo it because of immigration consequences. Imagine you had exactly these facts, only instead of Mr. Mulkern, it's Mr. Garcia, and these convictions give him immigration consequences. He is per se going to be removed, or it removes every defense in immigration. He doesn't have any strong ties to the United States, so there aren't any special circumstances that way. And the question comes down to, would it have been rational for him to have gone to trial instead of taking this plea? And I don't think this court would have any difficulty saying it would have been irrational for him to have gone to trial in that circumstance. And all I'm saying is that when the shoe is on the other foot, and we have facts as stark as these, the same logic should apply. I think I am winding down a little on time, so I do want to address the sort of remedy and issue of whether we need a remand. I don't think so. And the reason is because as the cases come to the court, first of all, you owe no deference at all to Judge Hogan because she did not preside at trial. She did not hold an evidentiary hearing. The record is purely documentary, and so a de novo standard of review applies to her decision. I don't think any material facts are really disputed here because we know exactly what the content of the advice was. We know exactly what the content of the plea negotiations was. And all we're really doing is on step one of Safarium, we're asking whether the advice was within constitutionally acceptable norms, professional norms. And on step two, I think taking this as the flip side of those accepted plea cases, what we're asking is whether a reasonable person in Mr. Mulkern's position, whether there's a reasonable probability that a reasonable person in his position would have taken this deal instead of going to trial. And I think that essentially asks whether there's any rational reason for him to go to trial given these facts, given the absence of any reason not to go to, any absence of the reason to insist on going to trial. And so I think both of those are fundamentally, they reduce essentially to legal questions that you can answer de novo without need for a remand, which is really convenient for me because while the motion was pending for a really long time, trial counsel passed away. So I think this is my best shot there. I do see that I have 19 seconds left, so if you have no further questions, we'd ask that you reverse.
I do have one question, and that is, what would you say is the difference between the best plea offer and the ultimate sentence?
So the best plea offer was, as I recall, a soft 5.5 to 7 as the range. And so versus the ultimate sentence was 8 to 10, and that was a mandatory minimum. So he's serving 8 years no matter what, as opposed to a soft 5.5, which I think implies that with good time credits, it could be somewhat less than 5.5 actually serving in actuality. That's sort of my read of it. I may be wrong about that, but I think that is a substantial delta to shave off. And so from a perspective of rationality, there really isn't that isn't a rational explanation for going to trial when you have no defense.
Mr. Malcarn was familiar with the criminal justice system prior to this offense?
He did have prior drug convictions.
And Mr. Leppo was privately retained?
He was. Thank you.
Thank you, counsel. Attorney McGowan.
Good morning, Your Honors. May it please the Court, ADA David McGowan for the Commonwealth, asking this Court to affirm the denial of the defendant's motion for new trial and its underlying convictions. Turning to Justice Singh's question a moment ago as to what was the most generous plea offer, I'm not sure that's an easy question to answer because what it hinged on was a probationary period. The longer the committed time, the reduced probation. So it depends on the defendant, him or herself, to determine what their chance of success on appeal would be to calculate what their exposure is. I think all of the plea offers were fairly close to what was received after trial.
So was it rational if you had basically no real defense? Is it rational to go to trial rather than taking one of these pleas, given the difference?
Well, you don't, at the time you're making that decision, you don't know what the ultimate sentence is after trial, and typically, in most cases, it's something more than was offered before to avoid the business of the trial itself. In this case, Attorney Leppo, quite experienced, familiar with the trial judge, also quite experienced, having a sense of what the likely range might be. Both affidavits are silent to that point, but I think that is not, that dynamic, I think, informs the decision that it's more reasonable than not. I think there's nothing to suggest that going to trial in this context is wildly unreasonable. But that's also based on what we're really here to discuss is what was known prior to those, the decision to go to trial. And in here, as both the SJC and this court's jurisprudence has said, we try not to get into the Monday morning quarterback of this particular decision without more. The exposure was a 20-year man-min, and the offer was a 6. So here we are much, much closer on a very, I think, I disagree with my brother's characteristics. I think many attorneys can disagree with discrete trial strategy and how people would peg the Vegas odds of success at any given moment, but all attorneys are cautioned about giving real solid odds ever. We don't guarantee results. We hedge all the time, and we're made fun of societally for doing so. But there's a reason for that. We can't guarantee outcomes. And in this case, Attorney Leppo explained his rationale for describing the jump ball, the pros and cons of his case.
Was it a jump ball? What was the defense?
The jump ball was what Mr. MULKERN saw during the motion to suppress. So unlike many defendants, when their attorney explains the theory of, in this case, Mr. MULKERN saw it in action in a different context with different emphasis. There it was for suppression, not for establishing beyond a reasonable doubt. But here, there was stuff to work with in terms of arguing the credibility of these officers. Indeed, experienced officers, both investigative and in terms of testimony, they could not account for certain discrepancies in the paperwork. They could not account for when certain drugs were documented photographically in the timing. They didn't remember.
As you stand here right now, do you agree or disagree that the government's case was strong?
Oh, I do think it's strong. I would gladly go to trial as an ADA in the Commonwealth with this amount of evidence. But it is not a slam dunk, particularly in Suffolk County.
Do you think that not a slam dunk is equal to a jump ball?
I think in this case, Attorney Leppo, in describing it as a jump ball, said either the judge is going to credit our theory of these officers weren't squared away enough to find beyond a reasonable doubt that what they found when they found it is legit. They didn't have to prove that these drugs were never Mr. MULKERN's, just reasonable doubt that it went down the way it went down. And here there were facts, both established in the motion to suppress and established at trial, that gave the trial judge the opportunity to find reasonable doubt. And I do think that a jury, as Attorney Leppo feared, would see the vast amount of drugs and not give that the lack of proper documentation, maybe less known to the public of what's required, but definitely known to the trial judge.
And Attorney Leppo considered and explained that to his client, right?
Indeed, indeed. And so it was Mr. Mulkern's decision to go to trial. He had 3 different plea offers, depending on what his state of mind was. One may be more attractive than the other, but 3 offers below the far lower than the max exposure. And instead of accepting any of them, he proposed a counteroffer that was rejected. And so Mr. Malcarn had all the information he needed. The cases where advice regarding the rejection or acceptance of a plea become problematic for the court, there aren't too many, are when an attorney misinforms or doesn't inform at all a client of a plea offer from the government. That's problematic. Or informs incorrectly the consequences of the plea, the minimum mandatories, or, as my brother mentioned a moment ago, the immigration consequences of certain pleas. That's where we get into serious trouble. I have found no cases, my brother cited one in I believe the 7th Circuit, where there was a problem with the plea. But there, not only was the trial strategy in the court's eyes absolutely meritless, the defendant was deemed quite vulnerable in working with an interpreter through the course of trial. And so I can't find any case where that's problematic. There's one unpublished case out of this court, MYSZKOWSKA from 2017. In that case, the defendant was saying, I want a plea. There was a plea on the table, and the defense talked her into going forward on a Second Amendment case. This is before Heller McDonald had really run its course. In that case, there was a judge, they found ineffectiveness and rejected the conviction because the defense theory, one, was unsupported by the law at the time, and to be vindicated would take years of appellate litigation, of which the mandatory sentence of 18 months would have been served. So they deemed that was wholly unreasonable from start to finish.
Was he acquitted on any offenses?
Mr. Malcarn, as the court pointed out, lesser includeds were found on some of the charges, but I don't believe any of the counts were a full acquittal, no. No. The court has no further questions.
I don't see any. Thank you very
Thank you,
much. The case is under advisement. Thank you both. Our next case is Commonwealth versus Jonathan VELEZ, docket number 24P873. Good morning, Mr. Locke.
Good morning. May it please the court, ADA Michael Locke for the Commonwealth. To begin, the motion judge here abused his discretion in not first finding that the defendant had raised a reasonable inference of discrimination before he held an evidentiary hearing. As I acknowledge in the brief, it's moot because he ended up finding that anyways later once the hearing was held.
Let's back up.
Sure.
Tell us what the 2 prongs of Long require.
So first, it's the defendant's burden to establish a reasonable probability that the stop was the result of racial discrimination. The judge is supposed to...
Does the judge make that at an evidentiary hearing?
No, that is based solely on the submissions by the defendant. And here, the judge didn't make such a determination before he held an evidentiary hearing. When it gets to the evidentiary hearing, it flips to the Commonwealth's burden to rebut that reasonable inference. And we know that the trial judge, or the motion judge, didn't make that finding because he says, I believe on page 5 of the transcript, I haven't read any of the papers yet.
So putting aside what the judge ultimately concluded, one of your issues is with the process. And so it seems to me that what you're arguing is that the motion judge, this is my word, not yours, collapsed the 2 into 1. At the end of the day, and I don't mean this to be flip, but so what, ultimately, with the decision that he renders?
I think Your Honor is correct. Here, I don't think it matters because the hearing was held. I think it is moot. But I just wanted to brief it because I've seen this happen repeatedly, and the Commonwealth is prejudiced when this happens because the Commonwealth doesn't know ahead of time if it needs to get an expert or something like that. The whole point of the Long framework is to put the Commonwealth on notice that at an evidentiary hearing, it is now their burden. So they now have to present evidence to rebut such a claim. And again, here, it's moot, it doesn't matter. But just in general, I would ask the court to reemphasize that it is a 2-step framework and that motion judges need to first make that initial finding before an evidentiary hearing is scheduled. Moving on to the actual substantive issue here, the motion judge committed an error of law where he allowed the defendant's motion after crediting the officer's testimony that he could not see the driver before he chose to make the stop. It's simply not possible for a stop to have been made based on a racially discriminatory reason if the officer didn't know what the race of the driver was. This is
Not plausible at all, you think?
It's not. Without any other, there could be additional facts, but we don't have anything like that here. The motion judge clearly twice credited the officer's testimony that he didn't know who was driving that car.
So a necessary element is some evidence that's credited that the officer knew the race of the person. There's no other way.
Not in this case, no. There could be something, there could be another fact. Perhaps here, the defendant here was Hispanic. Perhaps if the officer had heard Spanish music from the car or something like that, but still had not seen the driver, that I certainly think that could rebut or be a factor in the defendant's favor. But we don't have anything like that here. We have the officer testifying he had no idea who was driving that car, and there are no other facts that indicate the race of whoever was that driver.
And you don't disagree with any of the facts that are found by the judge?
I don't believe that the judge made any incorrect findings of fact. It's just, it's simply here, it's the Stroman case that was out of this court. If the judge credits that testimony, if the officer gets up there and the judge does not credit that testimony, it's over for the Commonwealth. But where an officer credibly testifies that he doesn't know the race of that driver, it simply can't be a race-based stop.
Was he familiar with the area?
Presumably, yes.
In the community?
Presumably, yes.
So does that increase the odds of perhaps stopping somebody who may be of Hispanic ethnicity in that area and community?
I think it could, but there's nothing, no evidence, none of those facts were in before the motion judge. The motion judge doesn't refer to them at all. He explicitly credits that this officer doesn't know the race of the driver.
What did the expert testify, or the expert say?
The expert said that based on his statistics that he's put forward, which the motion judge seemed to not credit, or at least not credit the methodology that the expert used, the expert said that the officer was more likely to pull over Hispanic drivers than other members of the Chicopee Police Department.
So what if the officer knew that?
If the officer, I'm sorry.
Was aware of that? What if his experience, how long had this officer been on the job?
I believe it was 4 or 6 years, I believe.
So what if that was his experience? That more often when he pulls folks over, they're of Hispanic descent in this particular area and community. Does that factor into the calculus at all?
If the officer, I think it would, but again here, there's no indication of the race of this driver. I mean, that would be, yeah.
I understand that.
That would mean essentially that the officer wouldn't then be allowed to make any stops, because then the officer would be presuming that every stop he makes is of a Hispanic driver.
In a particular area, perhaps.
Perhaps. But again, here, I don't think we have that evidence. The motion judge didn't have that type of evidence before him. Again, I'm not disagreeing. There are certainly instances where an officer could testify that truthfully, that he did not see the driver, where there might be other facts that a motion judge could point to and say, no, but you would have had some reason to believe that this driver was a person of color. But here, we simply don't have those.
So statistics alone cannot establish this premise unless you have somewhere in the evidence where you can draw an inference that the officer knew the race of the driver.
I believe that's correct. Because there's no way that there's simply, it's common sense. There is no way that an officer could implicitly or explicitly make a racially based stop if they don't know the race of the driver.
I want to ask you something about the judge's treatment of the expert testimony. So is this a case of the judge simply saying, Commonwealth, you could have attacked this expert, you didn't do your job well, so I am left with no reason to discredit the expert?
I think that's kind of what the judge was thinking, but the expert did testify, and the Commonwealth did have the expert testify that that his statistics didn't take into account the time of day. The holes that the judge complains about in his decision were elicited at the hearing. I'm not sure where the judge got that feeling from. And the judge himself asked some of those questions at the hearing, and because he obviously didn't put much weight into methodology of the expert. So I think the motion judge did have in front of him a rebuttal from the Commonwealth as to the statistics.
So are you saying that the judge's findings regarding the expert testimony were internally inconsistent? Sort of saying, I don't believe this and I don't believe this, but the Commonwealth didn't cross on that.
Right, and that's part of the third argument in my brief where he abuses discretion, where he doesn't take into account the fact, he seems to just accept, or he says, basically, I have to accept the testimony of the expert, even though he apparently makes it pretty obvious that he doesn't credit the methodology. And I'm not sure why he does that. It's pretty clear. Again, during the hearing, you can see him struggling with the statistics and how the methodology doesn't seem to be pretty straightforward or correct, we'll say. And I'm not sure exactly why he decides to just wholesale say, I have to accept them when he clearly doesn't believe in them. If there are no further questions, I would rest on my brief.
Let me just check. Thank you very much.
Thank you.
Attorney Cohn, did I say that correctly?
Yes, it's Raisler-Cohn.
Raisler-Cohn, I apologize.
No problem. Josh Raisler-Cohn on behalf of Mr. VELEZ. Thank you. To start off with, I disagree with the Commonwealth's characterization that the judge did not credit the expert testimony, because in fact, in the findings of the court, in the conversation at argument that's documented in the transcript, the judge clearly says that he credits both the expert and the officer.
Well, but he does say at 32, the court has, quote, serious reservations, and then further on, the court has, quote, further reservations. So to
Yes.
Judge Singh's point about being perhaps internally inconsistent.
So I think the idea of raising questions about a methodology is categorically different than the Commonwealth establishing that the methodology is wrong, to start off with. So I think and I talk about this briefly in the brief, the possibility of rebuttal is different than actual rebuttal. So raising questions about an analysis is different than showing that the analysis is wrong. And the two things that the judge raised, that the Commonwealth just alluded to, that were questions that were raised by the judge, were about the time of day of the traffic stops in the statistical analysis. And also, the other thing raised by the judge was a question about a different style of analysis. Instead of comparing the rates of stops of this officer to other officers, the judge raises the idea of a veil of darkness analysis, which is an analysis that really focuses on time of day and the ability to see into a car.
What do you point to suggest that this was a discriminatory stop?
So I think the totality of the circumstances here and the statistical evidence combined make it within the discretion of the trial court to find this.
So let's leave the statistical evidence just aside for a minute and just talk about the facts.
Yes.
What do you point to?
So in this traffic stop, the officer had two opportunities to observe the driver. When he first saw the car and he was behind the car, when he described seeing the obscured license plate, he describes the car making a left turn right in front of him. At that point, the driver...
Stop you for 1 second. Do you agree that the judge credited the officer's testimony?
I agree that the judge generally credited the officer and the expert. I would point the court...
He says greatly credits.
Yes, greatly credits both the officer and the expert.
All right, so that means that the officer didn't see the driver.
So I actually don't agree with that. I think the findings of the court are important to look at in a specific way from our position. The findings of the court generally describe facts without preface. It was this time, it was this day, it was this
Okay, no.
time of day. And
Paragraph
then in
6, Officer Graham testified, this is who he
Right.
greatly credits, whatever that means, that at no time prior to stopping the vehicle could he observe the driver. That's not equivocal.
So I think, unlike the other paragraphs in this findings of fact, that statement is prefaced by the officer testifies to this. That preface of the officer testifies is not present in any other way. And I think one way to read this that's consistent with the way that the court decided is that the court is crediting that that's what the officer said, which is not the same as crediting the fact of the information that the officer is testifying
Okay,
to.
so Officer Graham testified Paragraph 1, I'm not trying to be difficult, I promise you.
No, I understand.
The court greatly credits the testimony of Graham, and then he says Graham testified. You read those together, he credits his testimony that at no time prior to the stop could he see the driver. It's the only route I get to.
I absolutely understand the court's question. I think for us, part of the answer is looking at the way that the court credits both the statistical analysis and the general testimony of the officer. I think Commonwealth versus Garner, Commonwealth versus Eric Garner also talks about the way that a statement of generally crediting a witness does not mean that you're actually crediting the facts of each individual statement that the officer said. And then when you look at the opportunity to view, you look at the pattern of this officer's traffic stops, which it's somewhere between 1 in 15,000 and a 1 in a million chance that his rate of pulling over Hispanic drivers would happen.
I know you want to get to the stuff that helps you, but let's talk about the stuff that doesn't. So if he greatly credits the officer in his testimony that he never saw the driver, right, then you were going to tell me how we get to the discriminatory stop.
So I think what we have here is we have an opportunity to view. We have the testimony that the officer is telling the court that he didn't see the race of the driver. We have a vigorous discussion of the role of implicit bias. And we have the court's instructions in Commonwealth versus Long that the reason why statistical evidence is so important is because when implicit bias is a factor in traffic enforcement, it may be a factor that the person who's making the decision, the officer who's making the decision, is not even aware of why they're making the decision that they're making. And in that context, when you understand that there are two distinct opportunities by the officer to view the driver, when we have these overwhelming statistics, and when you look at the way the court balances credibility and also the weight of the evidence, two things can be credited and one can be weighed more than the other. And in that situation, I think that's what happened here.
Doesn't the judge have an obligation to put in here a fact that lets us know something about, even though the officer testified that he didn't see the race of the driver, I find that he did. He had this opportunity. Doesn't the judge have to put that in these facts?
I think the clearest discussion we have of that is in the transcript. That's the argument after the evidentiary portion of the hearing. It's pages, I think, 105 to 116, where there's a conversation between the court and defense counsel and the prosecutor about the role of implicit bias in decision-making in an officer in the context of an officer making a denial like this. In Commonwealth versus Stroman, which the Commonwealth talked about, which is out of this court, the court certainly acknowledges that a statement like this by an officer, by a blanket denial by an officer that they saw the driver, the court certainly acknowledges that that can be enough if that statement is credited, if the judge credits the fact that the officer did not know the race of the driver, and that one of the things that the court should be doing, as they talked about in Stroman, is also looking at the totality of the circumstances as to whether or not that statement is credible. In Stroman, there was no opportunity to view the driver. The officer was behind the car for mere seconds. He was behind the car. In Stroman, the car never turned. In addition to our case having a left-hand turn where the driver's side window would have been visible to the officer for an opportunity to view, then the officer sort of lost sight of the Jetta, pulled his car over, waited for the Jetta to come back, and the Jetta drove straight towards him on the opposite side of the street, not in a dangerous way, straight towards him, and the two cars passed each other before the officer then pulled the car over, which means the officer had two different opportunities to see the race of the driver. I understand that the officer testified that he did not see the driver. In the context of an argument on racial profiling, I think the context of the whole hearing has to be taken into consideration, where the officer, what else is he going to say?
No, but you agree with the premise that there has to be somewhere in the evidence something from which you could draw the inference that the officer did see the race of the driver.
I agree
you
that that's
agree on
true.
that basic premise.
I agree that's true, and I think that is present here, because there are two distinct opportunities that are described in the findings of fact and in the testimony that are opportunities for the officer to have viewed the driver.
But after at 7 and 8 of the findings at record 30, after the judge goes through the left and the following and the left, he makes the finding. The Jetta was pulled over in the vicinity of Absolute Auto. Quote, Officer Graham still could not see the driver of the Jetta. This is after the left and the left. So to Judge Singh's point, he's made the finding. He couldn't see him.
He's continuing to describe that that's, I agree that he's
No,
continuing
he
to
didn't
describe that that's the officer's.
He made a finding. Graham still could not see the driver, still could not see.
And I think when you look at the rest of the facts of the case about the opportunity to view, you look at the way the judge credited both the overwhelming evidence of racial profiling by this officer, the pattern that he pulls over 42% of the stops that he makes are of.
This was the judge at the hearing that watched the witnesses testify. We can't do that, right? You're asking us to essentially make a finding that's different than what the motion judge found. The motion judge found that Graham could not see the driver.
I think with the facts in this case and the court crediting the testimony of the officer that he could not see the race of the driver, when you couple that with opportunity to view, when you couple that with the role of implicit bias in decision-making and the way that people aren't always aware of
What case do you have that says that that's what we're supposed to do, that we're supposed to go outside the findings?
So I think when we have facts in the record that are undisputed, which I think is the testimony in this case is undisputed, the description of the opportunities to view are undisputed. They weren't incorporated in the written findings of fact, but they're undisputed fact in this hearing. I think that is certainly something that can be considered by the trial court and by this court.
Do you have a case?
I can provide one. I don't have one off the top of my head. I apologize.
So it's
I
12:35?
think Jones-Parnell is the case that talks about.
Well, Jones-Parnell says that uncontested facts in the record, but I want to know if there's a case like this where a judge says he couldn't see the driver, but you want us to consider other things in the record.
No, there are, no. There are, I believe our understanding from talking to people in the trial court and in the DA's offices that of this type of litigation, of these equal protection claims about traffic enforcement, in the last 5 years since Commonwealth versus Long was decided, we believe there's only 3 cases that have been allowed in the trial court, and 2 of them are currently on appeal. So there's not a lot of discussion about upholding trial court decisions, because the trial court generally, despite the SJC's admonition that we should be making this an accessible remedy to defendants, it's rare for a trial court to allow one of these motions. I do appreciate.
So hold on. So the facts of this case are that at 12:35 in the morning, the officer sees this vehicle, and it looks like his license plate is partially obscured, and his taillights are dimmed. Is that what
was the description.
Drew his attention to the vehicle? Okay. And but he doesn't stop him the first time he sees that, right?
He pulls out behind him.
He doesn't stop him the first time he makes that observation. Is that fair to
Correct.
say?
Correct.
Okay. Then what happens?
So then the white Jetta that Mr. VELEZ is driving makes a left-hand turn, exposing the view of the driver to the officer.
I get that part.
The officer then loses sight of the car. The officer stops on a main street where he thinks he'll be able to intersect the Jetta when it comes back. And in fact, the Jetta does come back, drives towards the car and past it. Then the officer pulls behind the Jetta, follows it for a few minutes until the road is no longer windy, and then activates his lights and sirens to pull the car over.
Okay. And at what point does he tell the driver why he stopped him? And point to that in the record for me, please.
So after the traffic stop, he approaches the driver. At that point, the officer makes observations of the driver.
At what point does he tell the driver why he's being stopped?
I don't remember that he did. I don't remember that specifically. What I remember is the officer then going into a description at the hearing about other observations that he made in the traffic stop.
So he never told the driver why he was being stopped?
Not that I recall, but I can look back at the record about that. I guess in going back to one of the questions that was brought up earlier about whether statistics alone are sufficient to establish equal protection claim like this. I agree that statistics are not necessarily the only thing that are available, but they are something that a defendant can rely on to establish the reasonable inference at the outset. And then the burden shifts to the Commonwealth to rebut the statistics and the totality of the circumstances. I think in this case, it was not an abuse of discretion for the judge in the totality of the circumstances here, where the judge is evaluating credibility and also is evaluating the weight of the evidence. in a place where we have two different types of credible testimony, then it goes to weight. And when the judge evaluated that, the judge determined that the Commonwealth had not met their burden to rebut the totality of the circumstances and the statistical evidence in this case. I think Commonwealth versus Gonzalez, which is a 2018 case, part of what it talks about is that on an appeal, the fact that a different judge could have come to a different conclusion on a set of facts, that doesn't mean that the case has to be reversed if the decision is within the realm of reasonable alternatives. And I think that what we have here is we have a court making a reasonable decision, looking at a variety of factors, looking at totality factors, looking at statistics, thinking about credibility, thinking about the role of implicit bias, which of course could mean the officer is not aware of the basis of his motivation. And in that context, the judge is finding that the Commonwealth did not prove that race was not a factor. And that is not the decision that every judge would have to come to, but it is a decision that's within the realm of reasonable alternatives.
What's the standard of review?
It would be an abuse of discretion, or it would be clear error on the findings of fact, and it would be an abuse of discretion on the ruling as well.
Do you agree that the process used here was appropriate? Do you disagree with the Commonwealth's initial take that there should have been a determination made before the evidentiary hearing?
I certainly agree there was no prejudice to the Commonwealth here, that they were on notice for over 100 days of the defendant's argument and had the defendant's report. They asked for a continuance in order to decide whether they were going to file a Daubert challenge or not, and they made a strategic litigation decision not to do that and not to call an expert. There was no surprise about what was going to be talked about, and the hearing was scheduled for an evidentiary hearing. I think when these hearings are scheduled for an evidentiary hearing on the merits, that is an implicit finding, just like with the Fourth Amendment motion to suppress. That's an implicit finding that the defendant has met their burden. If the Commonwealth has an objection and wants to say, we don't think they met a reasonable inference standard, and we want to object, and we want to have a hearing on that, of course, that's totally reasonable, and I think it's totally appropriate for it to be addressed in that situation. But that did not happen here. The Commonwealth answered ready at the hearing and did not object. We would ask this court to affirm the trial court's decision that it was not the only option that was available, but it was a reasonable option that was available to the court, and we ask the court to affirm the motion to suppress.
Thank you both. The case is under advisement. We are now going to take a brief 15-minute recess. When we return, we will hear the next case on the list, which is IRMINA. Okay, our next case on the list is IRMINA Mizakowska, I'm sorry if I've mispronounced that, versus the Massachusetts Bay Transportation Authority, docket number 24P1324. Mr. Heinlein.
Good morning, may it please the court. Before I begin, I just wanted to comment that I did have, on the recommendation of the court officer, the opportunity to attend the ceremony earlier this morning, and it was quite moving, and it was refreshing to get the sense of camaraderie between all the justices, so it was an honor to be there. It's an honor to be here, so thank you.
You're trying to cozy up to us now.
Yeah, so please just rule in my favor, I'm all set. Thank you. The main thrust of our argument is to asking you to take a look back and take a look back to what the state of the law was and what the legislature was explicitly saying in Chapter 161A, the MBTA's enabling statute, back in 2021, before July 29th of 2021. The underlying incident in this case happened in October of 2019, and the presentment letter, which I prepared and sent, was done in January of 2021. At that point...
What would prompt you to even look at the enabling statute at first blush, rather than just 258 to serve it on the general manager of the MBTA? Why look behind that?
Well, I think I'm not sure it got into my brief. In fact, it probably isn't my brief, but it's certainly in the record. When I get a case and I am looking, at that point in time, I use the Wayback Machine, which the court may be aware of. So I just go and take a look, go on the relevant websites on the Wayback Machine at that point in time to see what's going on at that point in time. And so that's not that got me to the enabling statute, to answer your question directly, but it did get me to what was going on in terms of the governance of the MBTA at the times that were relevant to my client's claim. And so in doing that, asking you to take a look at that point in time, because at that point in time, prior to July 29th of 2021, the MBTA was governed by the Massachusetts Department of Transportation.
Can I interrupt you one more time?
Of course.
So it says serve it on the general manager and the rails in, what's the other language attached to it?
The rail and transit administrator.
Okay. And that begs the question, what is that? Who is that, right? But why not just send it to that person anyhow, without regard for who receives it? You sent it to the AG, we sent it to the governor, we're going to send it to where they tell us to send it to, and then if we get pushback, we can always say, we sent it to where you told me to send it to.
Well, because the most direct answer is because at that point in time, again, looking at the structure of the MBTA and who was there at that point in time, there was no such person.
Right, but that's not your concern, right? Your
well,
concern is adhering to the statute.
But it is my concern to the extent that if I'm sending it to a position that doesn't exist, am I actually sending it? And so,
but why not like a belt and suspenders? Why not send it to where they tell me to send it, but I'm also going to send it to the governor, and I'm also going to send it to the AG and some of these other folks as a matter of caution?
And I apologize if I'm not answering you directly, but thank you. Because at the time there was no general manager and rail and transit administrator for the MBTA.
Was there a general manager?
Yes, there was. But
So then why isn't this case controlled in all material respects by Corin Hall?
because Corin Hall is a case that was about sending the presentment letter to the wrong person at the MBTA.
Well, didn't you send it to the wrong people here?
No, because my position is that under 161A explicitly, at that time the legislature said that the MBTA is going to be governed by the Board of Directors of the Department of Transportation, and that the Secretary of the Department of Transportation is the executive officer of the Department of Transportation. And so this is not a Corin Hall situation. My argument is not that I should be sending it to the MBTA, My argument is that at the relevant time, it was the Department of Transportation that governed the MBTA, and that under Chapter 258, I needed to send my presentment letter to the Chief Executive Officer of the governing entity.
So Judge Saroof concluded that the operational and management control over the MBTA as set out in 161A does not equate to presentment. Why is he wrong?
Well, he's not wrong in the sense that that doesn't equate to that doesn't equate to governance, but why he's wrong is because under 161A Section 38, and talk a minute about the purpose of presentment, and I think all courts, this court, the SJC, have all agreed with the proposition that the purpose of presentment is to investigate, evaluate, resolve, if possible, claims. 161A Section 38 says that the board, as the term is used in 160A, is responsible for all of those functions. And in the relevant time frame, the board is the board of directors of the Department of Transportation. So even had I sent the presentment letter to someone, and I would suggest undefined at the MBTA, at that point in time, that person at the MBTA did not have the authority to meet the purposes of presentment under the Tort Claims Act.
Is the MBTA a subsidiary of MassDOT?
I don't know the answer, and candidly, I'm not sure what the court means by subsidiary, but I do know, for example—
Is the MBTA an independent political entity separate and apart from MassDOT?
I believe it is now. I do not believe it was then. Correct. Because if you look at the statutes I've talked about, when July 29th, 2021 came along, the statute, the MBTA enabling statute, specifically says, as of that time, that the MBTA now, you're going to have your own independent board of directors. And so until that time, they were under the governance of the Mass DOT, and I did note in the briefs that were submitted by the MBTA in connection with this case that it says MBTA/Mass DOT even now. So I'm not quite sure what the interplay is now, but I honestly don't believe that that's particularly relevant to the court's consideration today because, again, it was the Mass DOT. So back to my point is, had I sent the presentment to the MBTA at that time and under the law as it existed at that time, the MBTA did not have the authority to investigate, evaluate, and compromise claims at that time. At the time, it was solely vested in the Department of Transportation's Board of Directors. And therefore, because it was vested in the Mass DOT at the time, the only way I could comply with the presentment requirements was by sending it to the Secretary of the Department of Transportation, the Chief Executive Officer, and to Attorney General Healy at the time, because presentment for any department of the Commonwealth can be made upon the Attorney General, which is why I sent it to her and why I sent it to the Secretary. And kind of the belt and suspenders approach, as the court made reference to earlier, I also sent it to the other board, the chairman of the other board, which at the time had governing responsibilities over the MBTA, the financial management, and forgive me if I don't remember the name, but Mr. Aiello was the chairperson of that other governing board of the MBTA at the time.
Do you agree that the presentment requirement is applied strictly?
Yes, within the confines of what I was going to raise next is where Chapter 258, Section 1 says, and we don't dispute, for the MBTA, that is the general manager and rail and transit administrator. The problem is it was impossible, as of that point in time, to strictly comply with that language.
Why?
Because
why couldn't you just send it to the general manager and whatever that title is? Why couldn't you just send it there? Why was that impossible for you to do?
Because I did not see that that position existed, for one.
Wait, when you say—
It doesn't make it impossible for you to send it there.
Fair, point taken. Correct. But if it's also, I believe, appropriate when I look at that, and I suspect there's some ambiguity there, because is the general manager and rail and transit administrator one person or two? I suspect a fair reading is probably that it's only one, because I haven't seen any cases where this court or any other court has required presentment to be made to more than one person. So it doesn't make a lot of sense to me that the legislature would be saying that's two people. But in any event, it is in my position that it's equally valid then to go to the default presentee. And what I mean by that is if I consider there to be some ambiguity, if I look and I see that that position doesn't exist, so I'm going to go to the default presentee being under 258, in all cases the chief executive officer of the public employer. And that's what I did. I saw the two governing entities, the DOT and the FMB, and I said, okay, I'm going to send it to the chief executive officers of those two entities. So even though that language is in the statute, I do believe it's ambiguous. That position did not exist. So the prudent thing to do, and what I believe the legally correct thing to do, was to send it to the chief executive officer, which at the time the legislature explicitly said was responsible for governing the MBTA and was explicitly responsible for meeting or effectuating the purposes of presentment to begin with.
So it appears that Judge Sharuf wasn't convinced by that argument, and then afforded you some more time just to see if they got noticed in any way, right? Because
yes,
that's what the statute calls for.
Yes.
You don't dispute that part? That
I do not.
Weren't noticed in any way?
No, I don't dispute that that's what Judge Sharuf allowed us to do, and it was, in fact, at that deposition that was done of the MBTA subsequent to the judge's order that we learned from the MBTA's designee that the general manager and rail and transit administrator was not a position in 2021. And so it's my position that bolsters.
But you agree the MBTA had no notice?
I don't recall if that question was actually.
I'm asking you as you stand here right now.
I'm sorry?
I'm asking you as you stand here right now.
Yeah, I guess as honest as I can be, and I will always be honest, is I don't know the answer. I don't know if they did or didn't. I don't think that question was asked directly during the deposition whether or not they got notice. Certainly they came in and defended the case. Certainly they came in and filed their motions and hired counsel, and so they got notice at some point, but whether it was a result of that presentment letter or service, I don't know.
But wasn't that the whole point of that additional discovery, to find out whether there was notice?
I think that question should have been asked, yes.
Weren't you afforded more time to determine that? Isn't that what happened?
Yes.
He pretty much took no action initially and said, hey, I'm going to give you some more time to figure out, because another way to satisfy and go forward is whether they got notice within this 2-year window.
Yes, but I'm not convinced that when you asked me the question about doesn't 258 require strict compliance on the presentment requirement, I'm not sure even if I could prove that the MBTA had notice that I'd be complying with that. Meaning that I don't know of any laws that say, well, even though the plaintiff didn't comply strictly with the presentment requirement, that nonetheless the MBTA got notice. Because in the Corin Hall case, clearly that didn't happen. Because the MBTA clearly got notice, the presentment was sent to the claim department.
But to the wrong person.
But the court said, even though they got notice, that's not good enough for presentment purposes under the statute.
Which is why I think your claim is weaker. I mean, the MBTA had some form of notice, but not to the right department.
I understand your position, and I don't agree with that, simply because I believe at the appropriate time, it was the Mass DOT that was responsible for governing, and that it was the Mass DOT that had responsibility for discharging the purposes of presentment under the statute.
Didn't we have a 30B6 depo where the keeper of the record said that there had been a ton of correspondence sent to the, quote, general manager and rail and transit administrator, and that the T considered that addressed to the general manager?
No, not that had been sent to the general manager and rail and transit manager, just simply that when correspondence like this come to the MBTA, that they are then directed to the general manager. So,
And I want to just, again, I know you've been over this over and over again, but I want to clarify, when you say there was no such position as general manager and rail and transit director. Administrator. But there was a position of general manager.
yes.
Okay, so this goes to your question of the ambiguity of that whether you're dealing with two people or one title.
Right, and the question of who is it that really should presentment being made to at that point in time based upon the state of the governance of the MBTA at that point in time, which was with the DOT.
I think we're going to have to leave it there. Thank you very much.
Thank you very much for your time. Appreciate it.
Attorney Walsh.
Good morning. David Walsh on behalf of the appellee, Massachusetts Bay Transportation Authority. May it please the court, counsel. This case is about sovereign immunity and the rule of law. I believe it was Mark Twain who said reports of my death are greatly exaggerated. In 1977, the Supreme Judicial Court had the opportunity to abolish the doctrine of sovereign immunity and indicated it would likely do so, but gave the General Court, the legislature, a chance to act first, which it did by enacting Chapter 258. Why that's relevant, at least for here, is particularly to this case, is that, as this court has noted numerous times, Chapter 258 is the exclusive remedy for negligence cases against public employers, such as this case, but also any action that's outside of the contours, outside of the requirements of Chapter 258 simply can't proceed. It's essentially a legal nullity. You can't sue the sovereign. The statute here is very clear and explicitly says who presentment must be made upon, and it must be made upon the general manager of the MBTA. The purpose of the statute, as this court has noted in Garcia and in De Vega versus Boston Public Health Commission, a case that I cite throughout my brief that is almost in all fours with the present matter, says that presentment must go to the highest official within a public employer, within that entity, so that that public employer, that official, can investigate, settle, make changes that might need to be made. That is the general manager.
Is there a rail and transit director?
That is, I concede that at the time, the specific words in the statute said general manager and rail and transit administrator. By my research, that is a title that was used by the general manager of the MBTA when that statute, when that amendment was made. Through the course of time, the exact title of the head of the MBTA has changed slightly. I believe Philip Eng now
uses... no, there wasn't a person with that exact title at this time. Is the answer no?
That's correct. There was not a person with that exact title. However, the first two words in that phrase are general manager, and there was someone with the title general manager. There's always been someone with the title general manager who's always been the chief executive officer of the MBTA, going back to 1964.
But doesn't this present an ambiguity? And if there's an ambiguity, how do we resolve this? Shouldn't the plaintiff get the benefit of that?
I don't believe it presents an ambiguity. To the extent it presents an ambiguity, it is very minor and not something that would present any sort of insurmountable hurdle here.
It's very minor unless you're MYSZKOWSKA, right? Forgive me for butchering her name.
I don't know that I've done much better. So I will say that that was not done in this case, but it has been done in thousands of other cases where, I mean, the MBTA receives something like 3,000 claims per year, and some fraction of that go into litigation, and by my estimate, we probably file maybe 10 motions to dismiss for improper presentment per year. So out of all those claims, and that includes unrepresented parties as well, they're able to figure it out. This is something where, and we go to rules of statutory construction, to the extent there is an ambiguity, the court must get a sensible interpretation, something that doesn't render the provisions of the statute a legal nullity or come up with some absurd result, and use common sense. And if you were to go, whether it's 161A, I think it's Section 3 that defines who the chief executive officer of the MBTA
Well,
is. It says general manager.
let's say we don't have a problem here. Let's say we agree that it does go to the general manager, but that's a sort of a different question. It's not really a statutory interpretation question. It's a different question how a plaintiff off the street should view that when they're trying to get guidance as to where they should give this presentment.
Right, and where you might go to, say, the MBTA's website, where it says who's in charge of the MBTA, the general manager. You might open up the Boston Globe, and certainly the general manager of the MBTA is not someone that has not been in the news media over the last 10 years or so. I think that you could say it's common knowledge that the general manager of the MBTA is in charge of the MBTA. You could take judicial notice of it. It's just something there's enough information that the MBTA puts out, say this is the person that is in charge of the MBTA. And when you look at that, you look at the statutes, you look at other material, and then you look at general manager and rail and transit administrator, you say, oh, this person, there's general manager, the first two words of that phrase. It's not something that's going to be a serious ambiguity or anything that using any amount of a modicum of logic and common sense that someone would not be able to figure it out. And I say that's borne out by the fact that presentment letters come in, even in 2020, 2021, that made it to the general manager's office. I would like to correct one thing that I think my brother made a slight mistake on. In that 30B6 deposition, the designee witness said that mail does come to the MBTA addressed to general manager and rail and transit administrator. Just, we'll put the title down. I guess we don't know who that person is. And when that would come in, that would be directed to the general manager's office because everyone in the MBTA understood that that's what was meant by that term. It's never an ambiguity.
So you're saying if it had been addressed to exactly that person, general manager and rail and transit administrator, it would still get to the general manager?
Absolutely. I can say from my own experience that those letters do, maybe not now, but the letters would make it, 100% would make it to the general manager's office.
Certainly, is it fair to say, let me not say certainly, is it fair to say that had the letter gone to the proper title and didn't find its way to the general manager, you can't fault the plaintiff for that, right?
No, I would agree with that. If they're able to prove that a letter was sent to that title and then, I guess, received by the MBTA, not lost in the mails or something like that, then yes, that we couldn't fault the plaintiff because, I don't know, I guess someone internally
There's nobody who has that position.
What's that? Pardon me.
Couldn't fault the plaintiff because there's nobody within the MBTA who has that position.
Yes, I don't 100% agree that there's no one with that position because I think that, again, this is we look at that and everyone in the MBTA understood that they were one and the same, the general manager and rail and transit administrator and general manager.
Everybody within the MBTA, but everybody from outside the MBTA says, I'm looking for general manager and whatever the rest of the tagline is, and there was nobody who had that title. Is that fair to say?
That's fair to say, not that exact title. But there was a general manager, and if somehow it was misdirected within the building, then that would not be the plaintiff's fault. I agree with that. But that was not done. I think the other thing that I want to raise is that there's issues about the governance of the MBTA, the board of directors, whether the Department of Transportation. I think that's a red herring. The statute, 258, Section 4, the presentment statute, those requirements operate independently of the governance. I disagree with my brother about the Department of Transportation. The MBTA is not a subsidiary. They're two separate, distinct political entities. I could give you much more information on that. But the statute operates independently. Presentment requirement operates independently. And in fact, LeGrant v. Boston Housing Authority references some emergency litigation or emergency legislation, pardon me, where the presentment requirement was temporarily, in certain cases, done away with. You didn't need to make presentment. So the legislature, because it's, again, this is a limited waiver of sovereign immunity, they get to make the terms that you must make written presentment, and this is who it must go to. If the legislature were to somehow say it must be delivered on green paper, then it would need to be delivered on green paper. And a court, a litigant, certainly not free to ignore those or to change these requirements. Again, if it's outside of the statute, it's simply not allowed. So I would ask the court to look at De Vega. I think that it is on all fours with this in that presentment, and the suit was against the Boston Public Health Commission, which, like the MBTA, is a body politic and corporate and political subdivision of the Commonwealth, and they made presentment on the mayor of Boston and on the attorney general. And relying on another case, Ogunkwu versus Stevens, which actually refers to the MBTA, a political subdivision of the Commonwealth is not the Commonwealth. It's not a constituent agency of the Commonwealth. It's its own entity. So serving presentment on the Attorney General was incorrect with respect to the Boston Public Health Commission. It's incorrect with respect to the MBTA. The MBTA is not the Commonwealth. It's not a constituent agency, authority, or anything like that of the Commonwealth. It's an independent political entity which is outside of the Commonwealth, certainly outside of the Department of Transportation. And I've just come back to the point that the statute is explicit. It says it must go to the general manager. And I don't believe that there's any real serious ambiguity or insurmountable obstacle in figuring out who the general manager is when looking at all the public information about who's in charge of the MBTA. If you have any questions.
I don't see any other questions. Thank you both. The case is under advisement.
Thank you.
Our next case is the Department of Children and Families and Another versus Father, docket 24P1416. As counsel gets set up, I just want to remind you that the case is impounded, so please do not use any names. And just so I want to make sure with our timekeeper, the appellees are splitting their time 7.5, 7.5. So we're all set on that. So Mr. Bench, when you're ready.
Good morning, Your Honors. I'm Nathan Bench. I represent Father, who's here with us today. The lower court's decision terminating Father's parental rights must be vacated because, first, the inconvenient truth is that Father was fit, demonstrated fitness at trial, and he is available for his children. The evidence of Father's engagement with the children, his visits, were very positive from testimony of social workers, from DCF's record, and there's statements that the children are bonded with Father, they love him, and he loves them. The burden is on DCF to prove by clear and convincing evidence that Father is unfit as a parent. However, the concerns, the judge stated the paramount concern was Father's substance abuse.
The judge acknowledged the bond between Father and the children, right?
Certainly.
So that's undisputed, that,
Yes.
that the children are bonded to the Father.
Yeah, and I would say it would be evidence that is relevant towards the fitness evaluation, and I do recognize that the judge...
Undisputed. But you agree that's not the sole factor?
Certainly. So moving into the substance abuse disorder, Father had relapses during the case. However, neither in the record or in the findings is there a pattern of any abuse or neglect that creates a nexus between his substance abuse and mistreatment or abuse or neglect of the children.
Well, you might get some pushback there. Is it fair to say that Father was unavailable in many instances as a result of his substance abuse issues?
Both in the findings and the record, Father testified and the judge credited that when he relapsed, he would arrange child care and would not...
My question's a little different. Is it fair to say that as a result of his substance abuse issues, Father was unavailable to parent the children on certain occasions, even throughout this trial?
I think that may be fair to say. I would counter with, is a parent unavailable to parent their children when they're at work? is a parent unavailable to parent their children when they take a vacation or go traveling for work. And I think that's true. They're not physically present, but a parent's responsibility in that case is to arrange childcare and with an appropriate caretaker. And during the relevant times, that was true.
So one of the instances that the department may refer to is at a time when father was unavailable, say, to take the children, I think it was to daycare. Mm-hmm. And at that time, there was a order from the court that mother was allowed to be with the children as long as she was supervised. Yes. And father elected to go to work and let mother, because he had to go to work, understandably, take the children even for a ride or less than a mile. However, she was unsupervised. So does that speak to the type of oversight that you're referring to that parents lend when they're...
Well, I would concede that that was a lapse in judgment on father's part. However, that was not in connection with father's substance abuse. That was in connection with work. And I would like to discuss that, DCF, in making reasonable efforts, one of the efforts that they can make is providing childcare. And I believe there's record evidence to suggest that father discussed this issue with DCF and perhaps made the request for additional support that would allow him to not be late for work and leave his children with an appropriate caretaker.
I'm going to just, with respect to the reasonable effort discussion, is that something that was raised below?
It was not raised in a Rashida motion, and certainly that would be the ideal. However, I did cite the case that talks about the opportunity for DCF to correct reasonable efforts when it is raised extensively in cross-examination. And I would like to talk a little bit more about that.
Adoption of Daisy forecloses that argument for the first time on appeal, doesn't it?
I don't believe so. And I think that this is also a different type of case in that DCF didn't just fail to make reasonable efforts, but what DCF did was make an ultimatum for third-party custody and then abandon reasonable efforts. The testimony from the social worker said, oh, we didn't do that. We didn't say the goal change. We didn't hold a permanency planning conference, which is required, especially in the context of when there's a negative prognosis for reunification. So I think it would be a manifest injustice to waive an issue where DCF, days before trial, began evaluating family members they were aware of over a year ago. And to me, it appears to be a last-ditch effort to say we made reasonable efforts to this alternative placement. And again, I would request that the court not waive this issue because in extensive cross-examination, DCF showed that they were aware of where their efforts had been lacking, and the trial did not happen in the same week. There was time within, I think, a month or a month and a half for DCF to correct some of those efforts. Even visitation came up during the trial, and although the judge disagreed that father should have makeup visits, that again speaks to reasonable efforts and puts DCF on notice of how this
Back to the termination question, I know much of your brief is focused on substance abuse or substance use disorder, but Judge Roach certainly also addressed the domestic violence in the family and the continuing relationship between mother and father, as well as your client's past criminal history. So can you speak to those issues?
Certainly, yes. And I would like to say that with the domestic violence disorder, there is a finding, finding 26, that the judge found that mother was a primary aggressor in perpetrating domestic violence in her relationship in the children's presence. While certainly, while certainly not ideal, the instances of domestic violence, I would also like to point out.
Well, but if mom is the primary aggressor,
Yes.
as between the two, and I believe in that same paragraph, the judge describes their relationship as toxic, which I take to mean on sort of both sides of that relationship. to Justice Desmond's point, dad is leaving the children, with somebody who is a domestic abuser, and we have lots of case law about that. So judgment call on dad's part, not just because of work, but now you layer the DV on top of it, more concerning to me.
I see. I would point out one thing is that the last occurrence of domestic violence pre-trial was in 2022, right? More than a year before the trial.
I don't know that the judge believed that, though, right? He didn't credit dad's testimony about when the last time, I think he says, despite father's claims to the contrary, the court finds father continues to be involved with the mother. Mother and father continue to seek support from each other, making further instances of domestic violence inevitable, which will also compromise their ability to attain sobriety and or remain sober. That's finding 26 at record 120.
Certainly. And I would say that, during that time, I think it was 2023, DCF did reunify the children with father, and we have that conditional custody order. And indeed, again, DCF was on notice of this. Father reached out for a change to the conditional custody based on his need for an additional caretaker, so he didn't need to abandon his children to go to work. Now, he was in kind of a catch-22 situation, and I would say that father is ultimately responsible for his choice and for the care of the children, yes, and DCF is responsible to give reasonable efforts in the context of the case. And here, there was no other support presented to father to care for those children and to be able to keep his livelihood as well, which would have counted against him in the trial as well. And I think, again, with the issue of reasonable efforts, there was no excuse for DCF to abandon those reasonable efforts. There was no exception to making them, although the testimony of the social worker suggested they believed that in a third-party custody situation, they could just let that go. I would also like to address the manifest unfairness of the situation in the trial itself with the double hearsay. I understand the hearsay was not objected to directly, and the statements, although no specific statements were made, the characterization of statements that father may have made to an undisclosed third party who called the clerk, who told the judge, were entered into the record.
But the department argues that it really wasn't reliance on that, it was reliance on father's own statements.
I would say
Isn't that what we get from the findings, is the reliance on the father's statements?
Well,
I think when asked specifically, doesn't father say something, I don't know what I would do? Or
yes, and I would like to talk about those statements, because I could use those expressions of frustration without a characterization of threat. I've heard friends say, over my dead body. I don't know what I would do if this happened. And I believe it's a discussion around, in the transcripts around page 460, where the judge is discussing this with father, and father says, even those statements I've made don't match the level of emotion that I'm feeling. And maybe not in so many words, not so...
but then doubles down and says, I don't know what I would do, right?
Right. I don't, and this is separation from his children, from his life. I don't know, as a father, I don't know what I would do in that situation. And I think I can say that as in really there's a blockage in my brain. I don't know what I would do. And I think that the unfairness, the unfairness comes from a few places. First of all, even when he is taking those statements from father, we don't know what those statements from the undisclosed declarant were. So how does father say, oh yeah, I totally said that, when he doesn't know what the statements were? On top of that, I think it was reasonable for the judge to ensure that there was safety in the courtroom. That, there's no question. And I applaud the judge. The first step he took was to engage the court clinician. The court clinician discussed things with father as, an expert in her field, And she came back and concluded, father is not a threat to himself or others. That's a professional opinion of a court clinician, and I think things kind of went off the rails after that when, despite his history of father, he says, you've always been a gentleman. I've known you for years. Despite the court clinician's discussion, when father makes these statements expressing his emotion and frustration, he calls this process of court cruel. And he feels persecuted. And he makes those emotional statements, and it's characterized as a threat. I think that is patently unfair, and I think that that colors the findings. Even if he doesn't say specifically, I'm relying on this statement, he does say there was a call in the findings and the conclusions. He says there was a call from someone in father's circle that described these troubling statements, and this had an effect on the trial. And I don't think it was a small effect. It's discussed quite extensively when the judge, and I would point out the judge also begins to testify about the statement before, as he puts it in the record, I believe it's day 5. He begins to testify about the statement, which a presiding judge may not testify as a witness, and there's no objection needed to reserve that issue on appeal. And after he testifies, then he begins to question father. On top of that, when father's attorney attempted to question him about his feelings and his intent to hurt anyone, the judge objected sua sponte and affirmed his objection. And there was no chance for counsel to cross-examine this somewhat anonymous declarant. There was, it was a catch-22. The judge made assurances on day 1. I'm making no findings, this is not evidence. And so to go from, I'm making no findings, this is not evidence, to, well, now we're bringing this in because I want it on the record, because we need something more in evidence. I don't think the judge would do that if he didn't feel it was necessary for building this case. And I think that puts him in a position of a prosecutorial role, and adds again to this unfairness within the trial itself.
Mr. Bench, we're going to have to leave it there.
Thank you very much.
Thank you. First for the department, Mr. Price.
Thank you, Your Honor. Good morning. May it please the court. Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the decision of the lower court that terminated father's parental rights. The court made the right decision. There was ample, uncontested evidence of father's unfitness, and that unfitness was likely to continue.
So you agree that father has a bond with the children? Do you agree with that?
Yes.
Okay. And did father miss a day of trial?
I believe he did miss a day of trial. His explanation for that was that he was feeling unsafe, which went to, I think, support the judge's ultimate findings as far as how it interpreted his mental health issues, and that they had not been adequately addressed in the past. This case, the department got involved with the family in 2018, and had been involved with the family throughout the years, and the action plans of the department stayed primarily the same because father was unable to address the issues that were concerning, which included the mental health issues.
And notwithstanding that, at some point, father was the sole caretaker for the children, right?
Correct.
And that was approved by the department.
Correct.
And father was responsible enough, so the department said, to ensure that mother wasn't left alone with the children.
Correct. The children were reunified with the parents on 2 occasions. There were ultimately 3 removals over approximately 5 years.
1 for one child and 2 for the other, right?
The older child was removed 3 times, and then together, the two children were removed twice.
What's the nexus between Dad's substance use disorder and his fitness?
The substance abuse disorder was long-standing over decades. The court made findings around that, and the court also made findings around how it was interwoven with the mental health issues. When father used, he was absent from the children's lives, leaving them with mother, who also had substance abuse issues, who father at times provided drugs for. So he's absent from their lives, leaving them with a sole caretaker who was also ultimately found unfit and had her rights terminated. So that's where the relation.
Understand the nexus. Give me an example of something that happened to put the children at risk when father was using. We have lots of evidence about the children being born substance addicted, and that all, in my view, really relates to mom. So I want to understand more about the nexus between Dad's substance use and his parenting.
Well, over the course of the 3 removals, at the first removal, father was not available because he was in substance abuse treatment. At the second removal, he was not available because of his situation and his struggle with relapse. And the third removal was based on the parents not taking a substance abuse screen in order to demonstrate that they were clean. So,
as to the first one, right, we're not going to punish Dad for going into treatment, are we?
no, and that's just...
Again, I'm having trouble with the nexus. Did he leave them unattended? Did he not get them to doctor's appointments? What do we have in the record about that?
Well, while the children were with the parents, they were behind medically. When father used, he was absent from the family and left the children alone with mother, who was also using at times.
And the younger child had a medical condition, correct? Something with an elongated skull? That was my memory.
Recall. I know that the older child required an individualized education plan that father was not aware of.
So are you essentially saying because of these issues with substances, mental health issues, the primary issue was unavailability?
No, I would say there was a constellation of things. Unavailability when he was using drugs. There was his unstable mental health, which played into that. There was domestic violence that took place between the parents, all of which, and the domestic violence which took place in front of the children. The judge made note of a lack of, not lack of visits, but inconsistent visits that the judge termed as having a lackadaisical attitude toward the visits. All of that together is what established the unfitness. And the mental health, the drugs, and the domestic violence were for over years, and there was no, despite the department's involvement, no meaningful benefit from what services he did get involved in. So,
just because I thought I had read this, at finding 131, the younger child had missed neurosurgical appointments for a diagnosis of craniostenosis at Boston Children's Hospital.
mm-hmm.
Is that an ongoing?
It's well, in the custody of...
She had surgery in 2021, and then the parents did not appear for scheduled follow-up appointments after the surgery, and then canceled the number of appointments. This is at finding 260. So a child's unique medical condition is also a piece of fitness, is it not?
Correct. Yes. If there's no further questions, we'd ask that you affirm the lower court's decision.
Thank you. Mr. Grammel, am I saying that right? I'm not. How do you say it? Grammel?
Grammel.
All right, I'll remember for next time. I'm
Thank you,
sorry.
Your Honor.
Mr. Grammel.
Good morning, Your Honors. I may please the court. My name is Sean Grammel. I'm here with my colleague, Kristen Gagalis, and we represent the two appellee children. They asked the court to affirm the juvenile court's decree and free them for adoption. I'd like to start with Your Honor's question about the nexus between substance use disorder and father's unfitness. I'd start in December of 2021, where the police were called to a domestic violence incident involving the parents. Mom suspected that dad was high. This is the one where the children were in the back of the car. They were involved in a physical altercation right in front of the kids. I believe dad pulled the car door shut, bloodied mother. There were statements about the children seeing dad hit mom, so that's one. A few months later, in February of 2022, this is when the children were removed the first time for the younger child, the second time for the older. Both parents had relapsed. Father acknowledged at the time he had relapsed, and the kids, when they went into custody, were a mess. They had night terrors. They were not medically up to date. The 4-year-old, the older of the kids, was still in diapers because he wasn't toilet trained. The younger child was nonverbal, and they were such a mess that the older child had to hotline for a while, which means he was moved house to house to house every single night because his night terrors were so bad, until he finally ended up at the current custodian's home. In August of 2023, this is after the conditional custody period, that's when father let mother take the kids to daycare. There were suspicions that mom was high. When DCF showed up later that day, there were suspicions that he was also high. They asked for them to go give screens, and well, dad couldn't. He said he couldn't produce urine, and mom refused. That same day, the younger child made statements that she had seen her father hit her mother. And then in December 2023, this is after that final removal, there's that kind of bizarre incident at a parent-child visit where father brings the cakes and he eats it with his hands, and he's walking around the restaurant not talking to his children. That's scary behavior for kids to witness. So those are just 4 off the top of my head of a nexus between father's substance use and his unfitness. So I think most of this case turns on very well-worn standards of children's welfare law, like adoption of Luke, adoption of West as for the reasonable efforts, and custody of Vaughn. I think that there are 3 particular sets of facts that are, to me, notable and distinguish this case and highlight that father was unfit. The first, I would just reference dad's own testimony as to his own fitness. And I'll just quote this at page 556 of the transcript appendix. Father testified, quote, "If the judge said take the kids home, I would have to say I can't." And then he continued, "I've got to admit I can't do that." And I give dad a lot of credit for testifying truthfully about what must be the most painful admission to make, but he made it not just once, but 3 times. At page 553, on questioning from his own counsel, "Would you be prepared to take the children?" I won't read the whole thing, but he said, "Honestly, I don't know if I would be today." And then on the next page, question, "You would be able to parent them?" "Like I said, I'm going to have to be really honest. I really just need some time." This was father's own testimony at trial. And this was the culmination of decades of substance use, mental health concerns, a very long carry, domestic violence, and all of that is cataloged in our brief. As far as the statements made during the trial about concerns about father's behavior, that's direct evidence of his mental health concerns and his inability to control his emotions. These were, I'm not really sure what the threats were, but again, we have what dad said at pages 459 to 470 of the transcript appendix, and there was no ambiguity in the questions from the court. The court asked, for instance, at page 463, if he would inflict harm on someone based on the outcome of the trial, and dad said, "I don't know. I have no clue what's going to happen. I have no intention to come here and harm anybody, but I just know I'm feeling stuff that I've never felt before in my life." That's what Dad said. And when the court said, I think it's a problem, you can't promise me that you won't hurt someone, at 470, Dad said, I don't know what's going to happen to me, bro. The third set of facts that I'd like to end on is that period of time when the kids were back in Dad's conditional custody in the spring of 2023. Things had gone well at the end of 2022 and into 2023, and I think it's great that they did get the opportunity to parent these kids again. That's what everybody wants to see. Mom relapsed, Dad asked her to leave, great, that's fantastic. March and April, though, he had the opportunity to parent these kids on his own, and that's what he's asking this court to give him the chance to do again, parent the kids on his own. And he admitted he couldn't do it. By the end of April, he was back in juvenile court saying, I can't do this. I need Mom to come back home. Mom who's fresh off a relapse, years of substance use, domestic violence, not a good situation. He had to go back and ask. And then, of course, the summer of 2023, there's lots of evidence in the record about how tense and toxic their relationship was, how they didn't have time for themselves. And then August of 23, they had relapsed again. So Dad had plenty of opportunity here to parent these kids on his own, but at multiple points of this case and in my clients' lives, he admitted, and again, I give him a lot of credit for being honest about something that difficult, he admitted he couldn't do it. That's why my clients seek to be adopted by their current custodians. They're happy, they're thriving, it's a fantastic home. I think these two custodians in particular have professional capacities, they have the experience as foster parents, they've adopted other kids, they are a fantastic fit for my clients, and that's why they're seeking to be adopted by those custodians.
The court ordered 4 visits?
I believe it's 3 post-adoption visits a year and monthly post-termination, which have been occurring.
Thank you.
Okay, thank you.
I just want to make a note. I did see that Dad left in the middle of the argument. I know that these are very difficult proceedings. Mr. Bench, I would ask that perhaps you check with your client and leave the building first, and I'm going to ask counsel to maybe wait in the hall for a few minutes and give Dad a chance to be able to leave the building in a calm way. I don't expect there to be a problem, but out of an abundance of caution, I think we should proceed that way. Chief Smith, if you could make sure that somebody's in the hall, that would be great. All right, the matter is under advisement. Thank you all. Our final case of the day is RC versus DI, docket number 24P1174. There is no appellee brief and therefore no appellee argument. The case is partially impounded, so Ms. Dennery, please do not use any names. Let me just get the timer set, and when you're ready.
Good morning, or afternoon at this point, Your Honors. My name is Erica Dennery, and I represent the plaintiff appellant in this case. May it please the court. So the question on appeal is simple, and it's really just whether the plaintiff still needs protection. So in granting an abuse prevention order under Chapter 209A, the court asked the question whether extension is for any additional time is reasonably necessary for protection of the plaintiff. And that's sort of a two-part question. First, the court will look at whether or not the plaintiff is currently in fear of imminent bodily harm, or whether or not the effects of past abuse continue to affect the plaintiff.
What's our standard of review?
In this case, it is for abuse of discretion, de novo. And so here you have a case where the plaintiff and the defendant entered into a dating relationship. They were longtime friends. They knew each other since high school. Initially, it was a consensual relationship, but early on, the plaintiff, she noticed that the defendant was displaying coercive, controlling behaviors. He showed her his gun when he heard that she had a male friend come and drop something off for her. They had
notwithstanding that, she elected to have sex with him the next week, right?
She did, yes. She proceeded to.
She couldn't have been too afraid.
Not at that point, no, Your Honor.
Okay.
But that fear, that fear arose during the second instance of sexual contact, in which it was consensual to begin with, and the plaintiff consented on the condition that the defendant go and get a condom. The lights were off. He got up, went to go do that. She heard him rustling around. He came back, so that's what she assumed that he did, was get a condom. And he began to penetrate her. She noticed that it felt different, and she realized that he actually wasn't using a condom in that instance. So this is a case really, I mean, it's of stealthing, which unfortunately...
Is that in the record that she heard him wrestling around and believed that he went?
Yes, it is, and I can point you to that specifically if you just give me a second here.
I'll find it.
Okay, thank you, Your Honor. Yeah, so she heard him wrestling around. He came back, penetrated her with no condom, and then the lights came on because she realized it felt different. There's a gun sitting inches from her arm. And this incident did occur at her own home. So again, he knows where she lives. He owns a weapon, and she's reasonably fearful of this individual based on that instance. I do want to point the court to the Rule 18G motion that we made, which I know the court hasn't ruled on that motion yet, but I would argue that the contents of that motion, which include a lot of Facebook posts from the defendant, go to the reasonableness of the plaintiff's fear.
But that was not in front of the trial judge.
I understand that, Your Honor, yes. So
how is it appropriate that we look at that?
I think it's appropriate in looking at that because the defendant has testified that he is not a continued threat. And
right, but we're reviewing the judge's decision. This isn't a new hearing.
Okay, that's fair, Your Honor. And so I guess if you're looking at the hearing that occurred in April,
what was in front of that judge?
In front of that judge was all the other materials. I mean, there's none of the Facebook posts, of course. But in front of that judge, we actually don't even have an articulable reason as to what really that judge considered, other than the fact that the pending criminal case had closed. They considered the fact that the defendant had complied with the order and that some amount of time had passed. So we don't actually even know what standard the judge was using in that instance.
Didn't the court also consider, when asking your client what she wanted to see happen, she said, I just need more time to process this?
Mm-hmm. Yeah, she did say that.
Say anything about being in fear. She's like, I'm just not sure, Judge. I mean, it seemed like the focus was on getting her Apple Watch back, not her safety.
Was understood, Your Honor. And I mean,
safety, the Apple Watch back. But even then, she said, I just need more time to process this, Judge. I'm not really sure. I just need, this is all kind of happening right now. But nothing about fear.
Sure, Your Honor. And so the thing with the Apple Watch, that was at the initial, or one of the previous extension order hearings in October, I believe, 2023. And her saying that she needed more time to process, I believe that was at the April hearing. And she did say that. But the point is she also pointed out the fact that she's still reasonably anxious and that she's just being in proximity with this individual is making her feel uncomfortable. At the January hearing, she also said, I just need to put some space between myself and this person because I'm so uncomfortable being near him.
Couldn't the judge the judge had the ability to just not credit that she was actually in fear at that point?
Sure, that's true, but the judge didn't point to anything saying that. Made these statements. She said, I'm sleeping with a broom behind my door.
Names.
Oh, I apologize, Your Honor. The plaintiff said, I'm sleeping with a broom behind my door. That's what the plaintiff said at the hearing in April. And it's unclear whether or not the judge credited that at all.
But can't we presume that the judge didn't credit that?
Sure, but without any record of what the standard that judge used.
But is it an objective or a subjective fear?
It is an objective fear. Yeah, and I mean, if you look at the record as a whole, yes, you can assume that the judge, you can assume that the judge did that, but there's no written record in the April hearing of what the judge considered other than those few things, which was the fact that the criminal case had concluded, that the rape kit was no longer being considered, that was not being prosecuted.
Well, wasn't there an issue about the hearing kept being continued because we were trying to see what happened with the criminal investigation, and the plaintiff had led the court to believe that something was still pending, and the judge later learned that it as of the last hearing date, it wasn't pending. So doesn't that lead us to the conclusion that the judge maybe did not credit this plaintiff when she had said previously that I just need more time because this case is still pending?
So I think that was an issue of confusion on the part of the plaintiff. I think she just wasn't entirely apprised of what was going on with the criminal investigation. And
No, didn't she specifically confirm in the last hearing that she did have that meeting?
did know that. Yeah, so I think, I mean, it got a little muddled there in that instance, but I don't think that detracts from the fact that she still continues to testify that she is in reasonable fear of this individual based on the effects of his past abuse. I mean, we know he has the gun, there's no order in place, and just because they're...
Did he ever threaten her with the gun?
Not that I'm aware of, Your Honor, no.
So she knew he had the gun from the outset. She elected to have sex with him after she knew he had the gun, and she saw the gun again after that. But he never threatened it. He never
No, that's true, Your
reminded
Honor.
her that he had a gun. I mean,
No, but
nothing of the sort, at least as it appears in the record.
That's true, Your Honor, but I would argue
What makes
that...
the fear reasonable then? You're saying it's an objective standard. How is the fear reasonable? They were friends, longtime friends. They had these encounters, and then they stopped having these encounters.
Well, I think objectively, anyone who is in the presence of a gun with someone who, I mean, just abused them in the fact that they abused their trust, they went and said they got a condom and it didn't, and then you see a gun present, I think, to be honest, if I was around a gun at all, I would be concerned, right? And you have an instance where this person just completely violated the plaintiff's trust. So yeah, she's going to be concerned that he might use it against her. He didn't in that instance, and again, he hasn't contacted her since the order. We know this.
Again,
and
objective standard, objective fear. Lots of people are around guns all the time.
Sure, but I think objectively, if you look at the fact of what he did to her and the fact that he knows where she lives, she's also testified that there was a vandalism.
What he did to her is he lied to her about using a condom on the second occasion that they had sex.
Correct. Correct. But that's still a violation of her trust, and he admits to that in the record.
What case do we have, reported or unreported, that's most similar to this one? Lying about using a condom
I mean,
as a basis for a 209A?
I don't have one, Your Honor, unfortunately. I mean, I've looked.
Are there any around the country that you found?
I haven't found any because, I mean, the problem is stealthing, unfortunately, which is what this would be classified as, is it's not illegal. And so...
What about even just the issue of a violation of trust equating to bodily harm, a risk of bodily harm to someone?
Right. I mean, again, Your Honor, I haven't seen a case where something such as like a violation of trust in this instance would be enough, but I don't think...
You know, for example, somebody could have an affair with somebody else. You violated my trust, and that's the basis to get a restraining order?
Well, I think that's very different because, I mean, in this case, like, you're in an intimate setting at the plaintiff's home, and like I've said, I mean, he knows where she lives. Her car was vandalized soon after. There's no proof that it was the defendant. I'm not saying it is or isn't, but like, her fear is reasonable because she also has a very public-facing job. She's out and about. He knows where she lives. He could find her. I think...
But that's going to be the situation with anybody who's in a dating relationship. They know where the other people live.
Sure, that's true,
right?
but I don't think everyone in a dating relationship is with someone who has necessarily abused their trust or who owns a gun and who makes concerning Facebook posts. I understand the court doesn't wish to consider that, but...
We can't.
We don't
it's
have the
not
Facebook
in the record.
posts.
Well, I submitted a Rule 18G motion, so I'm asking if the court would consider that.
Was it before the trial judge?
No, it was not.
We can't.
Okay, I understand. I mean...
They also didn't exist at the time, right? These are post...
No, they didn't,
event.
and I understand that. I think they go to the fact that this individual has said that he's not a threat to her, but the posts indicate otherwise. So I do feel like they need to come in, but I completely respect the court's decision for if they're not allowed to come in. I understand that. I mean...
Do you have a case that says that an appellate court can consider evidence not before the lower court judge that occurred after the case in question? It's not about what we want to do.
Right, I understand. And I mean, and no,
Cannot.
I don't. I understand.
I just want to be clear so that
Of
your
course.
client understands that.
Yeah, I understand. I do understand. I understand, Your Honor, of course. So, I mean, again, I just have to go back to the April hearing in which we don't exactly know what standard that the court was using in that hearing. I mean,
Well, we presume that the judge uses the appropriate standard.
but do we, when in the January hearing, the judge actually went through and laid out what the standard is? They laid out that the
It
standard
was a different judge. right?
No, I understand that, but if we're looking at the record, how do we know what the judge
Because
considered?
in the law, there is a presumption, absent anything else contrary in the record that makes you think differently, but there's a presumption that the judge knows the law and follows the law.
No, I understand that. I think if you look to the IMLE case, which was cited in the brief, I mean, in that case, it was similar, in which the judge admitted, that the plaintiff had previously obtained a protective order, and they were fearful, and the judge acknowledged that fear, but they didn't articulate what standard they were using. And so therefore, the court had to remand with the instruction on what standard to use so that it was clear to all what was being evaluated. And I think that's exactly what we have here. We have a case where the standard wasn't articulated. It's clear that, I apologize, Your Honor, that the plaintiff is still feeling fearful based on the record and what she's testifying to. So like IMLE, if we don't have it articulated, I think it's the same exact scenario as that, in which we need to remand with instructions on what that standard is so that we can be very clear on what exactly the court is considering when either granting or declining to extend the order. And so, based on that, if there are no further questions,
The initial restraining orders, the emergency restraining orders, they were only allowed for the first 2 months, is that correct? And then they went?
Yep, correct.
2 months
Correct,
at a
Your
time?
Honor. Yes, they were extended for, I believe it was 3-month periods at a time.
And that was tracking the criminal?
I believe it was, Your Honor, but I don't think it necessarily matters because there's a criminal case and there's a civil case, so they're under different standards. It doesn't really matter if there's a criminal case going on. If there are no further questions, I would like to rest on the brief.
I don't see any other questions. Thank you very much.
Thank
The
you.
case is under advisement. That concludes today's sitting of the Appeals Court. I'd like to thank our court staff, in particular Chief Court Officer Smith, our wonderful timekeeper, our law clerks, and our court staff. We are now in recess.
All rise.